Good morning. Good afternoon.
How are you?
Since good. Can we start? Can we start? Come on, Miss Matches.
Miss Milton, we first. Sorry, though, Miss Milton.
All right, y'all let me know where to go. I'm not getting in the middle of this.
Don't finish, no. There you go.
We ready, Your Honor?
All right, who do we have?
Miss Matches, position,
I have position 5, Miss Dorr.
and position 10 right after that one.
Okay. Good afternoon, Ms. Dorr. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Okay, who's the last?
We're doing this by video. Do you agree to have your case heard by video?
Yes, Judge.
Okay. Ms. Dorr, you've been charged in case 22 CR 000531F with battery, family violence, and criminal trespass. Is there a history, Mr. Howard?
The fifth arrest. Last arrest was last month for disorderly conduct. That was out of East Point. November 2020, suspended license. 2019, ag assault with a deadly weapon. And a 2019 DUI hit and run. I'm gonna look up the status of the ag assault, unless the state knows it.
I have that as an open case, Your Honor.
Hold on, let me see. There's no process.
Okay. Afternoon, Ms. Webb.
Good afternoon, Judge.
You can
May I
when you're ready.
proceed?
Yes.
Yes, Your Honor. This incident occurred on February 4th, 2022 at 2945 Blunt Street. That's BLOUNT Street, East Point, Georgia, where East Point Police Department officers responded to a fight call where they were met with a Mr. Corey Patton and a COREY Patton, POTTON, who is the defendant's boyfriend. Mr. Patton did inform the officers that he and the defendant had a fight earlier in the evening after returning home from dinner. While in the car, the defendant, and driving on Washington Road, the defendant attempted to take control of the car by pulling the steering wheel of the vehicle while Mr. Patton was driving. After Mr. Patton was able to secure the steering wheel, the defendant began punching him in the face with a closed fist. The responding officers did notate several injuries on Mr. Patton, including 2 swollen eyes, bruising on his cheek and his forehead, Your Honor. The defendant also broke Mr. Patton's cell phone, and he had to wait until they arrived at that incident location to be able to call the police. The pair do reside together, and our victim advocate did make contact with Mr. Patton, and he did inform her that the defendant will be moving out and that they will no longer be in a relationship following this incident, Your Honor. The state is worried that she has a risk of reoffending, considering that the previous aggravated assault arrest from 2019 out of Atlanta, and considering the violent nature of this incident. It's unclear to the state, and we're still investigating as to what actually caused that fight in the car, Your Honor. But we are concerned with witness intimidation, as well as we did speak with Mr. Patton, and he does not want to pursue charges against the defendant, Your Honor. But we are concerned that if these two are not able to amicably resolve whatever those domestic issues are, that we may be here again. For those reasons, the state is recommending a $3,500 surety bond, no further contact with Mr. Corey Patton, a stay away from that incident location, a 1-day anger awareness course, and no alcohol, drugs, or weapons while on bond.
Okay, thank you. Ms. McLeod, good afternoon.
Good afternoon, Your Honor.
Is this your case?
It is my case.
Okay.
I've had an opportunity to speak with my client. She is a veteran. She has been in the military, in the Navy for 5 years. She's currently a veteran. She is also a writer. She writes songs, and she's in the process of writing a novel. She and the defendant were coming from dinner and they got into an argument in the car and he attacked her first. And he, according to what she told me, he pushed his phone into her mouth and he was holding her face and attacking her. She says she has bruises on her hand and on her face and in her mouth by the time she got to the house. She said she did kick him, but that was because he had her pinned down in the car and was attacking her. So she contends that it was a situation where she had to defend herself, Your Honor. She's also told me that she is pregnant. She is pregnant by her boyfriend. She just found out about that since she was in jail. She's just found out that she's pregnant. So it is a concern of hers because now that she knows that she's carrying a baby, I've asked her if she's afraid of Mr. Patton, and she tells me that she's not afraid of him and that she doesn't have any kind of issues with him. And now that she's pregnant, that is where she lives and she doesn't have any other place to live and she's not in a position to find a place to live, Your Honor. She certainly is not in a position to bond herself out. So based on that, I would ask the court to consider giving her a signature bond. Of course, there could be a stay away condition, but if she's pregnant and carrying his child, I believe they probably would have to have some kind of communication. But I just wanted the court to be aware of that.
Okay, thank you, Ms. McLeod. Anything further, Ms. Webb?
Well, Your Honor, of course, that fact that she is now with child wasn't of privy to the state prior to now, but we will still request that no further contact order and stay away order from Mr. Patton because he has expressed that he does not want her to return to the home. He did express that she does have belongings and items at the home, and he will allow her to be able to come and get those items amicably, of course, but he does not want her to return. And from what he's told us, he is not looking to extend the relationship. Of course, this new circumstance will likely change that. But again, if these pre-existing issues can't be resolved peacefully, we may be right back here, Your Honor.
So it's going to be a $3,000 signature bond through the jail. No further contact with Corey Patton. Stay away from the 2945 Blount Street address. So she can go back to that address one time with an escort to retrieve any belongings that she may have there. Good luck
Thank
to
you.
Ms. Dorr.
All right, next we have position
Judge,
2.
I have one question. How are we
Mr.
breaking
Brandon?
it down? Let's keep talking.
Okay. Battery family violence is $2,000. The criminal trespass is $1,000.
Thank you.
Go through the jail. I'm sorry. Tell me who this is again.
Position 2, Mr. Brandon.
Okay, thank you. Good afternoon, Mr. Brandon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Brandon, you've been charged in case 22 CR 000532Y with willful destruction of a law enforcement officer and criminal trespass and damage to property. Is there a history, Mr. Howard?
It's his second adult arrest. Last arrest was back in December. Fleeing an officer, obstruction, misdemeanor, felony theft by receiver. He got open felony. He went to felony first appearance earlier, I assume. The charges is felony theft by taking, felony theft by receiving, cargo theft, and burglary in the first degree. I don't know what happened with the charge.
Ms. Webb?
Yes, Your Honor. Just for the record, I have those as open cases from a December 2021 arrest as well, Your Honor. This particular incident, however, occurred on February 4th of 2022 at the Family Dollar located at 1723 Lakewood Avenue, Atlanta, Georgia. The Atlanta Police Department responded to a theft call at the incident location. And when the officer arrived on the scene, he did locate the defendant inside of the store and approached him and attempted to place him under arrest. And the defendant did attempt to flee from the officer And the defendant also damaged products in the Family Dollar. And he was also picked up on a warrant for that burglary out of Atlanta when the responding officer ran his identification, Your Honor. For those reasons, we are recommending a $1,500 surety bond for the willful obstruction and a $1,000 surety bond for the trespass, a stay away from the Family Dollar at 1723 Lakewood Avenue, and 1-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, the state is concerned that the defendant has a high likelihood of reoffending and is a threat to the community, considering that he has those previous arrests for armed robbery and theft by taking and fleeing and eluding. And he also has those open cases out of Fulton and Atlanta for similar charges that are before the court today, including another fleeing, eluding, and theft and obstruction charge from December 2021. We do understand that the defendant is innocent until proven guilty, but the state is highly concerned with the defendant's criminal history and those pending open cases for the same and similar charges that he poses a threat and a high likelihood to reoffend.
Thank you. Good afternoon, Ms. Gann.
Good afternoon, Your Honor. Mr. Brandon, Marcus Brandon, is 27 years old. He is a long-term Atlanta resident. He has family here, including his mother, brothers, and also a 3-month-old child that the child lives with him. Your Honor, we are unopposed to the stay away at 1723 Lakewood Avenue. He has no reason to be at that location. Regarding his background, he completed the 10th grade. He is currently employed at a family-owned business, and that is Brandon Creative Landscaping. He has been in that position for the past six years. Your Honor, he disputes the allegations, and regarding my client's background, yes, he is presumed innocent, and he does not have, just doesn't have the history to inform the court regarding whether or not he's a threat to the community, specifically regarding the open cases. Therefore, Your Honor, I am requesting a signature bond on Mr. Brandon's behalf. And if Your Honor determines that he is ineligible, then a bond of no more than $1,000, and that would be $500 for each count, $500 for the willful obstruction, and $500 for criminal trespass. Again, we're unopposed to the stay away, and that concludes my argument. Thank you.
All right, so for the willful obstruction, it's going to be 1,500 SLB through the jail. For the criminal trespass, $1,000 signature bond through the jail, total of a $2,500 signature bond through the jail. Stay away from the Family Dollar at the Lakewood Avenue address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Brandon.
Yeah, thank you, Your Honor.
Next, we have position 6, Ms. Dunlap.
Good afternoon, Ms. Dunlap. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. You agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 000527B with theft by taking. Is there a history, Mr. Howard?
It's a third arrest. Last arrest was back in 2012. Simple battery, family violence, possession of a Schedule 1 controlled substance, cruise in the third. The controlled substance was cocaine. That was dead docket. The simple battery was dead docket. And a 2009 shoplifting arrest.
Ms. Webb?
Yes, Your Honor. The facts as alleged, this incident stems from a March 26, 2020 report where the defendant's former employers, the Dollar Tree at Metropolitan, located at 2034 Metropolitan Parkway, Atlanta, Georgia, reported to the APD that the defendant was caught on camera stealing Easter supplies while on duty at work as a clerk. The manager, Miss Arthur Rose, that is Rose Arthur, that's ROSE Arthur, ARTHUR, informed the responding investigator that they did want to pursue charges against her and that she was terminated after this discovery. Your Honor, the state is recommending a $2,500 surety bond, a stay away from that Dollar Tree located at 2034 Metropolitan Parkway, and no alcohol, drugs, or weapons while out on bond. The defendant does have a previous arrest and was picked up on this charge after being arrested for another theft by taking and aggravated assault incident that occurred just yesterday, Your Honor. So we do believe that she has a high risk of reoffending.
Thank you, Ms. Gant.
All right, thank you, Your Honor. Mr. Kateria Dunlap Powell was 32 years old. She has been in the Atlanta area all of her life. She is the proud mother of 7 children, all under age 15. She is now currently pregnant. She learned that again upon her being taken into custody. She is the primary caretaker of all of her children, and she is not receiving any support at this time. She completed high school, and she has been employed at Dunkin' Donuts for since 2019. Regarding the allegations, she disputes the allegations, Your Honor. We are opposed to, Your Honor, we are not opposed to a stay away order. She has no reason to return to that Dollar Tree store. And Your Honor, I did not hear about any convictions. We heard about arrests, but we did not hear about any convictions for theft. Therefore, Your Honor, I am requesting a signature bond for Ms. Dunlap Powell, as she is presumed innocent. And if Your Honor determines that she is ineligible, then a bond of no more than $500. Thank you.
$1,000 signature bond through the jail. Stay away from the Dollar Tree store on Metropolitan Parkway. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Dunlap.
All right. Thank you, Your Honor.
Say it again, Ms. Mueller. Thank you.
You're welcome. Who we have next?
Position 7, Mr. Gray.
Good afternoon, Mr. Gray. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, yes, sir.
Okay, thank you, Mr. Gray. You've been charged in case 22 CR 000529G with fare evasion, obstruction of a law enforcement officer, criminal trespass, and public drunk. Is there a history, Mr. Howard?
49 total between Georgia and Alabama. Last arrest was back in May for shoplifting, obstruction, 2 counts. The obstruction was dismissed. The shoplifting was a conviction. Before that was February 2021, probation violation, criminal attempt to commit robbery. September 2020, shoplifting, bond over the state court. 2019, probation violation, robbery. 2019, misdemeanor possession of marijuana, criminal attempt to commit a felony, criminal trespass. Another 2019 probation violation, arson in the first degree. 2 2019 arrests for shoplifting. 2018 failure to appear for obstruction. Had a disorderly conduct from 2018. It was amended to a non-fingerprintable offense. That was a conviction. 2017 simple battery dismissed. 2017 trespass, 2 counts, conviction. You want more?
That's good, thank you.
Okay.
Ms. Webb?
Yes, Your Honor. This incident took place on February 4th at the 5 Point Station, MARTA Station, Your Honor, located at 30 Alabama Street, where the defendant entered into the station and did not pay for the fare by pushing through the entry gate. The defendant was then told by the MARTA police staff to leave the station after they witnessed him skip the fares, Your Honor, and he refused to leave. The officers noted that the defendant did appear to be drunk, as he was extremely boisterous, loud, and yelling profanity in the station. And the defendant also refused to comply with the officers' commands when they attempted to place him under arrest, and was fighting and kicking Officer Colbreth, and that's CULBREATH, while they were placing him into custody. For these reasons, Your Honor, the state is actually requesting a lower bond than the preset bond. We're requesting a $2,250 surety bond for the fare evasion, a $1,500 bond surety bond for the obstruction, $1,000 surety for the trespass, and $250 surety for the public drunkenness, totaling $3,000, Your Honor. A stay away from all modern property and no alcohol, drugs, or weapons. We are making this recommendation because we do believe that he is a flight risk, as he has an FTA out of 2018 in Fulton County, Your Honor. In addition, we do believe he has a high risk of reoffending, as the defendant has several criminal trespass and other charges that stem from MARTA stations dating all the way back to 2016, 2017, and 2019, Your Honor.
Thank you, Ms. Webb. Ms. Kim? You're on mute, Ms. Kim.
Thank you, Your Honor. Mr. Gray is 48 years old, and he inherited a house from grandmother, and he has to pay taxes and bills on those houses. And he's been living here from ever since 2010, more than 12 years. And he has twin daughters as well. Even though he's not married, he has a strong ties to the community because of his responsibility as a housekeeper, and also he would like to make sure that the judge understands that when the incident happened, he couldn't take his medicine for his disability. He is making income only from Social Security disability. He has a bipolar, schizophrenia, and PTSD, and he has a lot of brain damage. When he was little, it has been continuous for his entire life. So we would like to request for a low bond, since he cannot make any bond payment, as currently he does not have much money left. Also, about the MARTA station, instead of stay away from the entire MARTA station, we would like to request to stay away from just 5 Point exit or nearby that area, because he does not have any other transportation. Without MARTA, he will not be able to go anywhere. Thank you, Your Honor.
Does he have a place to stay, Ms. Kim?
Yes, he has a place to stay.
All right, so for the fare evasion, $250 signature bond through the jail. For the obstruction, $1,500 signature bond through the jail. For the criminal trespass, $1,000 signature bond through the jail. And for the public drunk, a $250 signature bond through the jail, which makes it a total of a $3,000 signature bond through the jail. I'm not going to restrict him from MARTA unless he has a MARTA restriction already in place, which I did not hear about. So if MARTA wants to restrict him now or in the future, then that's up to them, but I'm not going to restrict him. No drugs, no alcohol or weapons while out on bond. I'm giving you the opportunity to get out, Mr. Gray, but you're going to have to make sure that you come back to answer for these charges, and you can't get in any more trouble over there at MARTA. You understand me?
Yes, sir. And when I had that LTA in 2018, I was at Georgia Regional Hospital. That's why I didn't come to court.
Okay, all right. Good luck to you, Mr. Gray.
Thank you. Bless you.
Also, who do we have next?
We have position 13, Miller.
Good afternoon, Ms. Miller. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 0000541A with battery substantial physical harm. Is there a history, Mr. Howard?
Yes, I got first arrest.
Good afternoon, Ms. Mitchell.
Good afternoon, Your Honor. Your Honor, in this case, the defendant battered her boyfriend, Mr. Andrew, spelled Andrew, Conn, spelled Conn, by punching him in the mouth mouth, causing visible bruising and lacerations on his mouth. The defendant was heavily intoxicated. When officers arrived on the scene, she was outside the front door, asleep on the ground with the smell of alcohol. Mr. Khan stated that he had to lock the defendant out of the house because she was hitting him all morning from 10 a.m. until he was able to get her out of the house at around 1:30 p.m. Mr. Khan was able to provide a video to officers which showed defendant punching him. Your Honor, the state's bond recommendation is going to be a $3,000 surety bond, no further contact with Mr. Andrew Khan, a stay away from address 185 Montag, spelled Montag, Circle, Northeast Atlanta, a one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, this is her first arrest in Georgia, but she does have one cycle in California, which was a battery family violence in 2017. The disposition is unknown, but due to the allegations and that arrest, that's going to be the basis of our recommendation today, Your Honor.
Have you spoken, or you of your office spoken to Mr. Khan?
Our victim advocate attempted to reach out to him and we left a message.
Scant.
All right, thank you, Your Honor. Ms. Michelle Miller is 34 years old. She was born in California, but she has been in the Atlanta area since June of 2021. She has a one-year contract here for work. She works as a makeup artist for local television and film studios. Your Honor, at this time, we are opposed to the stay away. Ms. Miller has informed me that that lease is in her name and that she pays all of the bills at that residence, Your Honor. I also tried to reach out to Mr. Andrew Khan, but was unsuccessful in doing so. So therefore, Your Honor, I am requesting that you not order a stay away, but instead issue a no violent contact order. Ms. Miller has completed high school along with college. She studied animation. She has 2 years in that area there. We discussed her employment. She has been a makeup artist for the past 12 years. Your Honor, she denies the allegations and given her lack of history for violence, specifically no convictions, I am requesting a signature bond as she is recommended through pretrial, and she informed me that she that battery charge was dismissed. And furthermore, Your Honor, if you're not inclined to grant a stay away, if you order a stay away, then Your Honor, I am requesting a one-time law enforcement escort to retrieve her belongings. Thank you.
There'll be a $2,000 signature bond through pretrial, one-day anger awareness. No, at this time, since no one's spoken to Mr. Khan, no further contact with Andrew Khan. Stay away from the 185 Montag Circle address. She can have a one-time police escort to retrieve any belongings that she may have at that address. No drugs, alcohol, or weapons while out on bond. Ms. Gant, as mentioned, if someone speaks to Mr. Khan regarding the no further contact and the stay away, depending on what he says, this can be modified. Anything further on Ms. Miller?
No,
Nothing further, Your Honor.
Good luck to you, ma'am.
thank you.
There was no anger awareness, was it?
That's correct, yes.
Okay.
Austin. Next, we have position 1, Mr. Austin.
Good afternoon, Mr. Austin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Do Judge Morrow.
Thank you. Mr. Austin, you've been charged in case 22 CR 000535G with simple battery against a police officer and obstruction of a law enforcement officer. Is there a history, Mr. Howard?
Third arrest. Last arrest I have was 2002, according to this bond assessment. Possession of marijuana, pled NOLO, DUI conviction. Before that was a first offender forgery in the first degree. That was from 1990. Let me see something, hold on. Yeah, that's all I have.
Okay. Ms. Webb?
Yes, Your Honor. I just wanted to clarify. I saw a simple battery against a law law enforcement officer out of Johns Creek from 2 days ago. From February 5th of 2021. I don't know, and a DUI from 2004 out of Fulton as well, as convictions, but I could be wrong on those, but I did retrieve that information from Odyssey, Your Honor. Nevertheless, this incident occurred on August the 30th, 2021. Officer Amber Johnson with the City of South Fulton Police Department responded to an intoxicated person call at 705 Lavender Lane, City of South Fulton, Georgia. Upon her arrival, she was met by the homeowner, Mr. Hardy, who informed her that he had hosted a party that evening and the defendant became too intoxicated and was asked to leave the home. The officer found the defendant sitting in his vehicle in the middle of the road with the car off and no keys. The officer told the defendant to get out the vehicle, and she had to coerce him out of the vehicle as he was intoxicated, and advised Mr. Hardy, the homeowner, to have someone to drive him home or contact a third-party ride service. The officer then began to conduct a field screening where she did determine that the defendant was intoxicated, had a smell of alcohol coming from his person, and had slurred speech and glassy eyes. And during the midst of her trying to assist the defendant to just leave the location, he became belligerent towards Miss Officer Johnson and began striking her, which she did hit her in the arm. The officer had to do the takedown method in order to place him under arrest, Your Honor. For these reasons, the state there is a preset bond, Your Honor, for a $5,000 surety bond on each count. The state is additionally requesting stay away from that 705 Lavender Lane, no driving, no alcohol, drugs, or weapons, in a one-day anger awareness course, Your Honor. We are concerned that the defendant has a risk of reoffending because he just received that charge for battery against a law offense. It was either a law enforcement officer or animal 2 days ago out of Johns Creek. And though the defendant was not charged with DUI in this particular incident, the incident does stem from the defendant being overly intoxicated while he was at that party that evening. And he was found sitting in his car in the middle of the road. And considering that previous or possible DUI conviction, Your Honor, the state is concerned that he has a high likelihood of reoffending.
Ms. Gant.
All right, thank you, Your Honor. Mr. Mitchell Austin is 57 years old. He was born in North Carolina, but has been in the Atlanta area for the past 35 years. He has family in the Atlanta, Georgia area, including a brother and a cousin. He's the proud father of a 17-year-old daughter who resides in Florida. He pays child support, and he states that he is current. Your Honor, we are unopposed to a stay away at the 705 Lavender Lane address. Mr. Austin informed me that he was at that location because there was a memorial celebration for his nephew who was tragically killed as he walked along Interstate 75. Mr. Austin completed technical college. He studied office technology and barbering, and he was also a barber instructor. Your Honor, he is disabled and has been so for the past 4 to 6 years. He has several disabilities, Your Honor, including PTSD, which causes him to be fearful when he is around flashing lights. He has carpal tunnel syndrome in his hands, which makes it difficult to maneuver objects. Therefore, he has numbness and tingling in his hands. And Your Honor, he also has several degenerative back conditions, which causes weakness and pain and numbness and tingling in his legs, which makes it difficult to walk. He uses a cane and a walker, and he does not have the ability to use any of those assistive devices while incarcerated. And lastly, Your Honor, he uses a CPAP machine for sleep apnea. And of course, he has no ability to use that machine while he's incarcerated. So it is our position that these medical conditions will make a difficult stay for him. He informed me that because of his limited means, he does not really have anything to pay toward bond. Therefore, I am requesting a signature bond as he is recommended through pretrial. Turning to the allegations, Mr. Austin denies these allegations. His medical condition, the PTSD again, causes him to feel fearful when he is exposed to flashing lights. And he stated that he did see flashing lights that night, the blue flashing lights from the police siren, and he became fearful. He denies being intoxicated at all. He, again, has obstructive sleep apnea, which causes daytime sleepiness and grogginess, and that would explain his behavior. And Your Honor, we've also, he also let us know about his back difficulties that cause problems with standing and walking. So therefore, Your Honor, he denies these allegations. And I conducted research as well in Odyssey, and I only saw this current simple battery charge. It says simple battery against a police dog or police officer. Your Honor, the DUI is far too remote. That was 20 years ago, and there is no allegation, Your Honor, that Mr. Austin was driving. So again, Your Honor, I am requesting a signature bond, and we are unopposed to a stay away. We are also unopposed to any conditions that would limit his ability to drive. Thank you, Your Honor.
And
All
Your
right.
Honor,
Yes, Ms. Webb.
just for the record, I just wanted to say that I did see that the Johns Creek incident had occurred 2 days ago. There's a case number on that at 2201685 for simple battery against police officer or correctional detention officer out of Johns Creek. That's all, Your Honor.
Okay, thank you, Ms.
And
Webb.
Your Honor, if I may, I would just add that if in fact that is there, it is open, and Your Honor, he's presumed innocent, that allegation as well.
Okay, so for each charge, it's going to be $1,000 signature bond through the jail, making it for a total of a $2,000 signature bond through the jail. Stay away from the Lavender Lane address. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Austin.
All right, thank you, Your Honor.
Thank you so much, Your Honor. And I do have the citations from John Creek.
Mr.
Hold on, Mr. Austin. You have a right to remain silent. I would suggest that you do that right now, okay? All right, good luck to you, sir.
Johnson. Next, we have position 9, Mr. Johnson.
Good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Johnson, you've been charged in case 22 CR 000539G with battery family violence. Is there a history, Mr. Howard?
Hold on. Jerome Johnson, 14 total. Counted 3 fade to appears. Last arrest was April 2021, fade to appear out of Douglas County. Got open case in Superior Court for theft by taking and battery family violence, 20 SC 175706. And he got bench warrants as well. Fade to appear one out of Douglasville. FTA warrant out of Fulton. 2019 fade to appear for theft by receiving suspended license. And a 2015 battery family violence arrest. That's it.
Ms. Mitchell?
Yes, Your Honor. The defendant battered Miss Amber Brown by striking her in the face during a verbal argument over social media and rent. Ms. Brown wanted the defendant to leave the apartment, but he refused. Ms. Brown had a busted and swollen lip along with blood on her clothes as a result of the defendant striking her. Ms. Brown and defendant live in the same residence. Ms. Brown also has 2 young daughters from a different relationship that also live with them in the residence. Both daughters were on the scene at the time the incident occurred. Your Honor, the state's bond recommendation in this case is going to be a $5,000 surety bond, no further contact with Amber Brown, a stay away from address 530 East Paces Ferry Road, Northeast Atlanta, Georgia, a 1-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, the state's concerns here is that the defendant does have a violent history. He has a simple battery family violence in 2020 and a battery family violence in 2015. He was also convicted of disorderly conduct in 2019. He also has 2 outstanding warrants, as pretrial stated, from Atlanta Sheriff's Office on May 4th of 2021 and August 13th of 2021 for 2 failure to appears. Even the warrant cautions that the defendant has violent tendencies. The state is also concerned defendant will be a flight risk. We have that he has 4 failure to appears, the most recent in 2021, and then another one in 2020 and 2 in 2019. So that's going to be the basis of our recommendation, Your Honor.
All right, Mr. Johnson, I see you there with your hand up. Put your hand down and I'll give you the opportunity to speak with your lawyer before she's done.
Ms. McLeod.
Ms. McLeod?
Yes, Your Honor. My client is 26 years old. He is originally from California, but has been living in the state of Georgia now for about 12 years. He tells me that he's employed at the Pepsi warehouse. He has been living with the alleged victim for almost a year, and they are raising 4 children together, 2 of whom are his and 2 are hers. He says that this was a verbal argument between them and that it did not, in fact, get physical, but they were talking very loudly, and he believes the police were called by the neighbors, Your Honor. He doesn't have any money to go towards a bond, so I don't know if the court would consider giving him a signature bond. If the court thinks he's not eligible for that, we would ask the court to give him as low a bond as possible, because he does need to get out so he can get back to his job.
Ms. McLeod, your client has his hand up.
Mr. Johnson?
I was the bench warrant in Douglasville was actually, they checked on that last night. It was no hold on that. That was no, it wasn't significant as far as I was told. And then the other warrant from May of 2021, I believe I just handled that earlier this morning.
All right.
Your Honor. Yes, Your Honor, if I may, our victim advocate did speak with the victim in this case, Ms. Brown, and she did say she does fear the defendant and does not want to have any contact with him and does want him to stay away from the residence. And I believe she is on the Zoom, so if Your Honor would like to sound for her, if she would want to speak.
If Amber Brown is on the call, you're gonna have to make yourself known if you want to speak. I see an Amber's iPhone there.
Correction, Your Honor. Our victim advocate has notified me that she does not want to speak.
Okay, that's fine. Anything further, Ms. McLeod?
No, Your Honor.
$3,000 good bond. No further contact with Amber Brown. Stay away from the East Paces Ferry address. No drugs, alcohol, or weapons while out on bond. If Mr. Johnson has any belongings at that address, he can have a one-time escort with law enforcement to retrieve those belongings. Yeah, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Johnson.
Thank you.
And the just so everybody knows, the reset dates for the SAP calendar will be February 22nd. All right, who do we have next?
Judge, we for Mr. Johnson, he had just one charge.
That's all that I see here, the battery family violence charge.
Okay, thank you.
You're welcome.
Next, we have position 3, Mr. Dewberry. You know what?
Good afternoon, Mr. Dewberry. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Okay, thank you, Mr. Dewberry. You've been charged in case 22 CR 000536G with criminal trespass and public drunk. Is there a history, Mr. Howard? Hold on, Mr. Dewberry. Let's say you have a right to remain silent. Everything you say can be used against you. You have a lawyer here that's representing you, and you'll be able to speak with her. Okay, so I'll give you that opportunity if need be later on. Let's see.
23 total.
Okay.
Last arrest was back in January. Trespass. He has an open case for entering auto with intent to commit theft or a felony. Criminal attempt to commit a felony. Criminal trespass. It's 20 CP 192339. Open case for criminal damage to property, second degree. 20 CP 193866. Open case for simple battery. 21 CR 007242G. And on probation for criminal trespass. 22 CR 000278G. You want more?
Okay, that's fine. Thank you, Mr. Howard. Ms. Webb?
Yes, Your Honor. This incident actually took place earlier this morning at the 5 Points MARTA station located at 30 Alabama Street, where MARTA police did respond to a call where someone was screaming at patrons and staff and using profane language. Upon their response, they were met with the defendant. The responding officers did locate a 60-day MARTA suspension that was previously issued to the defendant. And then upon arrest of Mr. Dewberry, the responding officer noticed that he had a smell of alcohol coming from his person along with slurred speech and was unable to maintain proper balance, which led the officers to believe reasonably that he was under the influence of alcohol. Those circumstances plus the boisterous conduct that led to the officers' arrest for disturbing the station, Your Honor. The state is recommending a $1,000 surety bond for the trespass and a $1,500 surety bond for the obstruction, totaling $2,500 surety, a stay away from all MARTA property, and no alcohol, drugs, or weapons, and a one-day anger awareness. The state is concerned that the defendant has a high risk of reoffending, Your Honor, as he does have that active 60-day suspension that was issued in MARTA from MARTA, Your Honor, back in December. In addition to, the defendant has also accrued another trespass charge out of Roswell just 3 weeks ago, and he has open criminal trespass cases from MARTA in 2020 and 2021 as well out of the city of Roswell, Your Honor.
Thank you, Ms. Webb. Ms. Kim?
Yes, Your Honor. Mr. Dewberry is 33 years old. He is living in Atlanta, Georgia with mother. He has been here about 10 years. And I wanted to talk to Mr. Dewberry's mother, but we could not get through the phone. And he has 11th grade that he completed. He could not finish his high school. He's not employed right now, so he cannot pay any money for a bond. So we would like to request that it could be a very low bond, like $100 surety bond. And also, instead of, we understand there are several criminal trespass charges against Marta. However, this is the only transportation that he has. So even though it is, second or third of offense, we would like to request for restriction, stay away only from 5 Points station. Thank you, Your Honor.
All right, Ms. Kim, your client had his hand up previously, so I told him
I
I'd give.
strongly recommend you not to speak anything, Mister, because anything you say will be used or it can be used against you. So please remain silent.
All right.
Hey, it gave me a public jump. A public jump.
Please.
Okay, Mr. Dewberry, you have the right to speak, but your lawyer is advising you not to speak, and I have also. Okay. All right, so for each charge, it's going to be a $500 good bond, making it a $1,000 good bond. Abide by the MARTA suspension, so he has to abide by whatever MARTA has required that he do. He has a suspension, I'm told, at the present time, so that will remain in effect. No drugs, no alcohol, or weapons while out on bond.
Your Honor, did you say $1,000 good bond on each charge?
a $500 good bond on each
Thank
charge.
you.
A total of 1,000, okay?
Thank you.
All right, good luck to you, Mr. Dewberry.
Hey, can I get a signature bond? I ain't ready for a signature bond.
Unfortunately, you're not, Mr. Dewberry.
Next, we have position 4, Mr. Durrell.
Good afternoon, Mr. Durrell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Say it again?
Yes, sir.
Okay, thank you, sir. You've been charged in case 22 CR 0000537E with battery substantial physical harm. Is there a history, Mr. Howard?
Counted about 8 cycles between the U.S. Army and Illinois. I got a 2019 arrest in Illinois for domestic battery. I don't see a disposition for that. 2017 sale of credit card or debit card. No disposition for that. 2015 forging of a debit card, misuse of credit card, suspended license, arrest. Got a 2015 says this is out of the Army, domestic assault in the 3rd degree. 2015 wrongful use of possession of marijuana. 2015 driving while under the influence / unlawful possession of a firearm. That's all. This is first Georgia arrest.
Thank you, Ms. Webb.
Yes, Your Honor. This incident occurred on February the 5th, 2022, where Atlanta Police Department responded to a dispute call at the incident location 2 Interlock Avenue. That's INTERLOCK Avenue Northwest, apartment 8-017. It's either IL or 1. It's kind of unclear on the report, Your Honor. Atlanta, Georgia, where they were met with the defendant, who informed the responding officer that he and the cross defendant, Ms. Shaolin or Shaylin, that is S-H-A. Shaolin. Thank you.
Yes, you're welcome.
Ms. Shaolin, SHOLIN Jones, were involved in dispute over a Wi-Fi password. The defendant informed the officer that Ms. Jones pulled a knife on him and that she and her guests locked him out of the apartment. The officer did speak with Ms. Jones and her friend, who had a recorded video of a portion of the incident. And the officer, excuse me, Ms. Jones, if you can just wait till I finish.
Ms. Jones, we don't interrupt anybody in this courtroom, okay? So I'm going to give you the opportunity to speak later, but until I call on you, then please remain silent. I apologize, Ms. Webb. Go ahead.
Yes, Your Honor. The officer did see that video where the defendant was depicted with holding a firearm on his person, but the officer did conclude that it appeared that the defendant was attempting to secure the weapon. However, the video proceeds and he sees the defendant while holding the gun and arguing with Ms. Jones, that he pushed Ms. Jones into a wall and she punched him back in the face. And after that, the pair just start hitting each other and screaming and yelling. And the officer did note that Ms. Jones' face did begin to swell while they were on the scene, Your Honor. The state is recommending a $5,000 surety bond, no further contact with Ms. Jones, a stay away from that incident location at 2 Interlock Avenue, no alcohol, drugs, or weapons, and 1-day anger awareness. We are concerned with witness intimidation and likelihood of reoffending. In this case, the cross defendant, Ms. Jones, did inform the officer that the defendant does not reside at that location, but that his name was on the lease of the apartment because she is subleasing that unit from the defendant and she pays the monthly rent. Although both of the parties were charged in this case, Your Honor, the state is concerned, considering that the defendant was holding a firearm during the dispute, that and those other previous charges for unlawful possession of a firearm from 2015, Your Honor, that it does pose a security risk to Ms. Jones in that community, Your Honor. Additionally, our victim advocate did speak with Ms. Jones earlier, and considering that she did receive a charge, we are concerned that she will not like to participate in the prosecution process out of fear that the defendant will evict her or terminate her right to be able to occupy that unit, Your Honor. And albeit that this is the defendant's first offense here in Georgia, We are concerned that a similar situation can arise if the pair is not able to resolve these issues amicably and without any violence.
Thank you, Ms. Webb. I see you there, Mr. Durrell. Hold on. I'll let your lawyer speak to you in just a moment. Mr. Howard, you had something additional?
He's wanted out of COB. The offense says intimidation. In parentheses, it says include stalking. Original charge, terroristic threats. He also has hold out of Conyers, failed to appear for possession of marijuana. TPO out of Florida. It's a different victim name on the TPO out of Florida. That's all.
All right, thank you. Ms. McLeod?
Yes, Your Honor. My client is 26 years old. He's a veteran of the Army. He was in the Army for approximately 6.5 years. He is an entrepreneur. He owns and operates a store here in Atlanta. I'd like the court to know that the co-defendant, Ms. Jones, and my client are not in a relationship at all, and they do not live together. My client has informed me that Ms. Jones had nowhere to live recently, having gotten into some kind of altercation with her boyfriend, and she asked him if she and one of her girlfriends could come and stay, and they came a few days ago, less than a week ago, to his house. They had come in late at night from work, and they were both drunk, the two young ladies, and they were asking him for his Wi-Fi password. And he was calling because there were some issues with the Wi-Fi, and he was calling to get it resolved when the defendant came, the co-defendant came and put her hands in his face. Then she went to the kitchen and she got a knife. So he tried to get the knife from her, which he was able to. And he has a gun. She went and she got the gun, and he was able to take the gun away from her. He was the one who called the police, Your Honor, because he just wanted to get these two women out of his house. I am asking that Your Honor consider that this is his place of residence. He tells me that Miss Jones trashed the place. She kicked a hole in the wall. She broke a chandelier and just generally trashed his place. He's very concerned about it. This is his home. She does not live there at all. She just came there a few days ago. So saying that it's subleased to her is absolutely untrue. This is his place, and he just allowed her and another friend to stay there. So I would ask the court not to put a stay away order because this is his home. I would also ask the court to consider giving him a signature bond, given that he really was a victim here, because what he's telling me is that she attacked him and he had to wrest the gun away from her because she threatened to kill him.
All right, thank you, Ms. McLeod. Ms. Jones, if you would like the opportunity to say something, I need for you to unmute yourself and activate your camera for me, and I'll have to swear you in, okay?
Okay. Okay.
All right, so raise your right hand for me. You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, put your hand down. What would you like to tell the court, Ms. Jones?
I never put a knife on him. I have messages where he offered me the apartment saying it's 20. He asked if I knew anybody that needed somewhere to needed an apartment or whatever. He had it available for $2,200 a month. I have those messages where we came to an agreement. And I have the whole video. I have video of everything. My roommate or my friend, she recorded the whole thing. So where he had the pistol, he threatened the pistol with me. He choked me. He slammed me to the ground. He knocked me out. And then, yes, I did trash the place after all this happened. Yes, because yes, I did. That's why I got my charges. That's when my charges came in at. But I have the whole, the whole 9 yards, from the messages to where he contacted me about the apartment for the subleasing. No, I did not. I had somewhere to stay. We did want to move, but I had somewhere to stay. So I have all the messages and the videos and everything that I can send over whenever you need.
Okay, are you still at the 2 Interlock Avenue address?
No, I'm at my first home where I have my house. Yes.
Okay, so you don't need to go back to the Interlock Avenue?
No, sir.
Okay. Anything further, ma'am?
No, sir.
All right, thank you. Ms. Webb, anything further? Ms. McLeod, the client has his hand up.
No, Your Honor, we just request that the court take into consideration the defendant's criminal history and the fact that a firearm was involved in this and those statements that were just made by the victim, Your Honor.
Thank you, Ms.
Mr. Durrell, I'd advise you not to speak. I'm here to speak on your behalf. I think based on the testimony that was given by Ms. Jones, it supports my client's position that this is his home, and she did admit to trashing the place.
All right, so I'm not going to keep him from his home, but it's going to be a $2,000 good bond, no further contact with Ms. Jones, and no drugs, alcohol, or weapons while out on bond.
Thank
All
you.
right, good luck to you, Mr. Durrell.
Thank you, sir.
Next, we have physician A. Gresham.
Good afternoon, Mr. Gresham. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent this.
Good afternoon, Judge.
Good afternoon, sir. Do you agree to have your case heard by video?
Yes, sir.
All right. Mr. Gresham, you've been charged in case 22 CR 000533E with improper erratic lane change, obstruction of a law enforcement officer, driving while license suspended or revoked, and reckless driving. Is there a history, Mr. Howard?
This is first arrest. He went to felony earlier though for possession of a Schedule I controlled substance, felony fleeing, possession of a knife or a firearm during the commission, felony theft by receiving. I don't know what his bond was, but he does have a Cobb County hold for fraud. That's it.
Ms. Webb?
Yes, Your Honor. This incident took place on May 17th, 2021, and the facts are alleged that Officer Russell with the Atlanta Police Department was patrolling the area when he saw the defendant driving a gray Jeep Grand Cherokee between Marietta Street and Cone Street. The officer witnessed the defendant fail to maintain his lane by erratically switching from lanes back and forth and once without signaling. Officer Russell then initiated a traffic stop and asked the defendant for his license and insurance. The defendant's license came back as suspended for FTA from July 30th, 2020 and August 18th, 2020. The officer requested backup, and once backup arrived, the officer informed the defendant to step out of the car. And when he approached the driver's side of the vehicle, the officer noticed that the defendant had his right hand on the gear shift, and the defendant suddenly just took off driving while the officer was attempting to proceed with an arrest. And he took off on northbound going on Ted Turner Drive at a high rate of speed and failed to adhere to said those traffic lights that are located on Ted Turner Drive, Your Honor. For those reasons, the state is requesting a $1,000 surety for the erratic lane change, a $2,000 surety for the obstruction, a $1,500 surety for driving while license suspended, and a $2,000 surety for reckless driving, totaling $6,500 surety, no driving and no alcohol, drugs, or weapons. Your Honor, the state does believe that the defendant has a high risk of reoffending and is a flight risk. According to our records, he has an FTA out of Atlanta from August 8th of 2019, an FTA out of Augusta, Richmond State Court from August 2020, and an FTA of, although attenuated, it is an FTA out of East Point from 1999. The defendant's license was suspended for failing to appear in those two jurisdictions, Your Honor. And those factors make the state concerned that he will not show up for court. Plus, the D did flee the scene in this case that is before the court today. The defendant also has that open case from 2 days ago that pretrial mentioned that includes similar charges as this case, including driving while license suspended, obstruction, fleeing and eluding, in the possession of the firearm, and drug possession charges, Your Honor. So the state does believe that he has a high likelihood of reoffending.
Thank you, Ms. Webb. Ms. McLeod?
Yes, Your Honor. My client is 24 years old. He is a sophomore at Georgia State University studying business management. He has substantial ties to the community here in Atlanta. The court will note that this is the first time he has been arrested. There are allegations that he has FTAs, but the fact is this is his very first arrest. And I would like the court to take that into consideration in setting a bond for him. Given the fact that he lives here and has lived here all his life, Your Honor, I do not think that he is a substantial flight risk. The charges that he's now charged with are all traffic-related offenses. So I think he's a good candidate for a signature bond, Your Honor, given the fact that he's a student here in Atlanta. And he's unlikely to go anywhere because he does want to finish his degree, he tells me.
All right, so this is going to be a split bond for the improper erratic lane change, $250 signature bond through the jail for the driving while license suspended, $750 SOB through the jail for the obstruction, $1,000 good bond, and for the reckless driving, a $2,000 good bond.
Thank you, Your Honor.
Right. Good luck to you, Mr. Gresham. No drugs, alcohol, or weapons while out on bond.
That's 3 good. How much through the jail?
$250 for the erratic lane change and $750 for the right, so a total of $1,000.
Thank
you. Okay. Who do we have next?
Position 11, McGee.
Good afternoon, Mr. McGee. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are holding by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. McGee, you've been charged in case 22 CR 000534A for simple battery, family violence, and criminal trespass. Is there a history, Mr. Howard?
This is 4th arrest. He went to felony earlier as well. Those felony charges: possession of cocaine, selling marijuana, possession of a Schedule II controlled substance. He was arrested also arrested on a probation violation, possession of marijuana with intent, and theft by receiving. He was arrested December 2021, battery, family violence. That's the same victim. That's your order. And 2020 possession of a knife or a firearm and selling marijuana, which is what he's on probation for.
What did I give him in December for a bond?
2,000 good. No further contact with Juanita Zealous. Stay away 765 McDaniel Street. No drugs. Third party transfer to visit child.
Thank you. Ms. Mitchell.
Yes, Your Honor. The defendant battered Miss Juanita, spelled Juanita, Zealous, spelled Zellous, by continuously slapping her in the face while she was sleeping. The defendant went through Miss Zealous' cell phone and saw some things he didn't like. The defendant slapped her until she was fully awake, and then Miss Zealous covered her face and head so that the defendant would stop. After the defendant left the residence, Ms. Zealous went to address 915 Washington Street, known as a drug house, where the defendant is known to hang out. She confronted him to retrieve her property at that time. Ms. Zealous and defendant got into a verbal argument at that location when the defendant broke her passenger side mirror. Ms. Zealous and defendant have been in a relationship for 4 to 5 years and have a 2-year-old daughter together. Your Honor, the state's bond recommendation in this case is going to be, as to count 1, a $4,000 surety bond, count 2, $500 surety, totaling $4,500 surety bond. No further contact with Juanita Zealous, third-party contact with their child, a stay away from address 765 McDaniel Street Southwest, Atlanta, Georgia, which is Miss Zealous' address, and the 915 Washington Street Southwest, Atlanta, Georgia, which is the second incident location where he broke her passenger side mirror. A 1-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, the state's concern here is defendant's risk of reoffending. He currently has 2 open cases, one of which is the battery family violence case from last year, where Your Honor gave him $2,000 surety bond, and the 2 probation violations this year on a drug charge as heard from pretrial. So, Your Honor, that's going to be the basis of our $4,500 surety bond recommendation.
All right, thank you, Ms. Mitchell. Ms. McLeod?
Yes, Your Honor. My client is 22 years old. He's always lived here in Atlanta. He tells me that he currently lives with his grandmother and he does not live with the mother of his 2-year-old child. He denies that he struck her. He said they did have a verbal argument, but he did not strike her. I'm sorry, Your Honor. He denies that he struck her. He said they just had an argument. He tells me that he is employed, he has a HVAC certificate, and he works as a contractor and has been doing that for some time. He tells me that he also works with his father. They have a towing business. As I said, he does not live with the mother of his child, so he is not opposed to no contact, but as they do share a child, he would like the opportunity to see his child. He doesn't have a lot of money to spend on bond, Your Honor, so if the court is not inclined to give him a signature bond, I would ask that the court set as low a bond as possible to allow him to get out of jail, to get back to work, and of course, to father his child.
Okay, anything further, Ms. McLeod?
No, Your Honor.
All right, the fact that he admits that he had a verbal argument with Ms. Zealous tells me right there that he violated my December order instructing him to stay away from her.
No, that was on November 30th. I had a warrant for a year, yeah, out of 2020. That's what I got locked up for. The warrant just popped up for November 30th for that.
Ms. McLeod?
I was just going to instruct him that he should remain silent.
But shit, I had a warrant November 30th.
Hold on, Mr. McGee.
You know.
When did I sentence him? Or when did I give him the bond? Mr. Howard?
December 6th.
The day did you give him the bond?
Right, the good bond.
All right, pull it up. December 6th, 2021.
Okay, so say it again, Miss.
I said he bound.
Right, so that's 5 months ago. And that case is still open, correct?
In state court, yes.
Okay, so Mr. McGee, I saw you just 5 months ago and gave you.
I saw you, but the
okay.
warrant.
Yeah, listen to me. You have a right to remain silent. I would suggest that you do. I don't care what the warrant says. 5 months ago, I gave you a bond and instructed you to have no further contact with Ms.
I haven't been around I haven't been around her. I haven't. It happened November. It happened in November. The warrant just popped up for that. I got locked up for a case in December 24, 2020.
I see what you're saying.
That's what I'm saying. I haven't been around her at all. 5 months ago when
I got you. I got you, Mr. McGee. All right, you're correct. Okay.
Thank you for the first time in history.
All right. So the warrant was in this incident date was 2021, but regardless, I saw you after that. I mean, so I saw you in December, and now it's February, right? So I told you back in December not to go around Ms. Zealous.
Around the defendant. It was a drug bust, sir. It was a drug bust. That's how I found out I had a warrant. I wasn't around the defendant. I haven't talked to my child since I've been out. I haven't
Your Honor, if I may interject, I think I can help resolve some of this.
Okay, thank you.
Okay, so their first incident happened December 24th, 2020. Your Honor heard that case and granted him a bond, a $2,000 good bond, December 6th, 2021. He was then arrested on this case yesterday, I believe. However, the offense for this case happened in November 2021, which preceded Your Honor's order by about 2 weeks. So for some reason, when he was picked up in December on the case that Your Honor heard from December 2020, for some reason that warrant from November of last year had not come through. So when he was picked back up, this is on a case that preceded your bond order by about 2 weeks.
I see, thank you.
It happened.
All right, so I got you, Mr. McGee, thank you.
The warrant was signed December 11th, 2021, and he got locked up December 6th.
Okay.
Weird.
All right, so this one preceded, I understand.
Yes, Your Honor.
All right. So I'm not going to give him more than what I gave him the second time. So for the simple battery, it's going to be $1,000 good bond. For the criminal trespass, it's going to be a $500 good bond, making for a total of a $1,500 good bond. Stay away from the McDaniel Street and the other address, incident location address. No drugs, no alcohol, no weapons while out on bond. And again, no contact with Ms. Ellis. All right, Mr. McGee, good luck to you.
All right.
Thank you, Your Honor.
Next is position 12, Middlebrooks.
I'm up on 1,500.
Good afternoon, Mr. Middlebrooks. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have the case heard by video?
Yes, sir.
Thank you. Mr. Middlebrooks, you've been charged in case 22 CR 000528J with distracted driving, giving false information, a law enforcement officer, driving without a valid license, and a second giving false information to law enforcement. Ms. Mitchell?
Yes, Your Honor. In this case, defendant was using his phone while stopped at a red light with his hazard lights activated. The defendant stated to the officer that he was doing Uber Eats. The defendant did not have a license on his person at the time. The defendant provided officer with 2 different names, 2 different birth dates. Jachavius, spelled Jachavious, Middlebrook, and Jachavius Middlebrooks with a S, and date of birth July 7th, 1997 and July 8th, 1997. Your Honor, there is a current bond on this case totaling $1,765 surety, $265 as to count 1, $500 as to count 2, $1,000 as to count 1, and $0 as to count 4, being that that was an added charge. The state is going to request that the bond be increased to a total of $2,265. So the bond will remain the same up until the 4th count, and we're going to add a $500 surety as to that count. We're also going to add the condition of no alcohol, drugs, and weapons. Your Honor, the state's concerned defendant risk of reoffending. The defendant does have an extensive history with several convictions. He has 5 probation violations from 2018 to 2021, 1 parole violation, 2018, 7 theft by receiving stolen property convictions from 2017 to 2019, and 1 burglary conviction in 2017. The defendant has been convicted of giving false information to law enforcement officers before in 2018. He's also been arrested on driving without a valid license in 2019 and 2020. He currently has a open forgery case from 2020. Your Honor, so that due to his history, that's going to be the basis of our recommendation, Your Honor.
All right, thank you. Ms. Mitchell, Ms. Campbell?
Yes, Your Honor. Mr. Middlebrooks,
He is 22 years old and he currently lives with his mother. And he is contributing money to pay for rent because his mother's, there are other fathers, but they are not giving any child support. So he is actually currently working to move furnitures at downtown warehouse. He's been working there for 2 years and he graduated from high school. When he was in high school, he competed as a chef. He wants to be a music producer. He's very young and he likes rapping and he's very good at keyboard and music. He also volunteers at the Heart organization to help out younger children to do homeworks and prepare for application for different events. And I believe that even though he has all these charges before, that was done when he was a juvenile. So we would like to disregard those. And since we understand that there are some others, we would like to request a low bond, maximum of $300 surety bond, Your Honor. Thank you.
All right, for the distracted driving, $250 signature bond through the jail. For the two false information, each is a $500 signature bond through the jail. For the driving without a valid license, a $1,250 signature bond through the jail. So it makes it a total of a $2,500 signature bond through the jail. No drugs, alcohol, weapons while out on bond, and certainly, Mr. Middlebrooks, no driving if you don't have a valid driver's license.
Yes, sir.
All right. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
Next, we have position 14, Perez.
Good afternoon, Mr. Perez. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Mr. Perez, you've been charged in case 22 CR 000542B with obstruction of a law enforcement officer, loitering and prowling, reckless stunt driving, and violation of the instructional permit or provisional license. Is there a history, Mr. Howard?
First arrest.
Ms. Mitchell?
Yes, Your Honor. In this case, the defendant was observed in the rear parking lot of North Point Mall that was not open for business and engaged as a spectator in a reckless stunt driving event. The defendant was encouraging the reckless operations of the vehicles in the parking lot by being in a large crowd of individuals filming and walking between vehicles that were actively engaged in stunt driving. The defendant fled on foot at the sight of officers approaching the event. Once the officers' lights and sirens were activated, the defendant fled into a silver pickup truck and was blocked in by the patrol car. The defendant placed the vehicle in reverse and attempted to back up, moving the vehicle several feet before being forced to stop by another vehicle that was fleeing the scene behind it. The defendant has only issued a Class CP license that requires the presence of an adult over 21 years of age with a valid Class C license in the vehicle while driving. The defendant operated said pickup truck with other minors in the vehicle and no Class C holder. Your Honor, the current bond on this case totals $3,625 surety. So that's going to be $1,000 as to count one, $1,000 count two, $1,000 on count three, and $265 as to count four. This state's going to request that the bond remain the same with additional conditions to stay away from the North Point Mall at 4500 North Point Circle, Alpharetta, Georgia. No driving and no alcohol, drugs, and weapons. Your Honor, although this is the defendant's first arrest, we're concerned at the allegations taking place, him being a minor, surrounded by minors at a reckless stunt driving event. Correction, not him being a minor, but him not having a valid license and driving a vehicle with minors in it. So due to these allegations, that's going to be the basis of our recommendation, Your Honor.
Do you know the names of who was in his vehicle?
Your Honor, it didn't state in the report. So no, we don't have that information at this time.
Okay, thank you. Ms. Kim?
Yes, Your Honor. Mr. Perez is only 17 years old. Actually, he's under 18. He is a minor. I wanted to talk to his parents, but I could not reach them. He is the oldest one among all the siblings, and he has younger children that he has to also take care of because his mother is having a hard time financially. He has been working at restaurant as a server. It's called I Love Pho restaurant. He's working there full time. This is his third week, and what all the cash that he's making, he's doing his best to pay for rent, so he and his younger siblings do not get evicted to the street and be homeless. And also, he is currently doing the 12th grade. Even though he is a little bit behind in his schedule, he's dreaming to be an auto mechanic, and he likes fixing cars, and he should be coming out and do all those more productive services for the community instead of doing, staying in the jail and ruin his future career. And also, he does not have a driver's license, of course. He has a permit. We do not oppose the stay away condition or no drug or no alcoholic. All those conditions we do not oppose. And yet, since he's only 17 years old, a student, we really think it is the best. He is the best candidate for a surety bond, and we request that you will award him, grant him the surety bond. Thank you, Your Honor.
Is he still in school, Ms. Kim?
He actually is planning to go back in August. He's kind of one semester off away from the school.
What time did this allegedly happen, Ms. Mitchell?
Between 10:30 and 11:45 p.m., Your Honor.
All right, so for the obstruction, $1,000 signature bond through the jail, loitering, $1,000 signature bond through the jail, reckless stunt driving, $1,000 signature bond through the jail, violation of the instructional permit, $500 signature bond through the jail, making it a total of a $3,500 signature bond through the jail. Stay away from North Point Mall, no driving, and he's going to have a curfew of 6 a.m. to 9 p.m. unless he's working. Okay.
Yes, Your Honor. Thank you very much.
Obviously, no drugs, alcohol, or weapons while out on bond.
What's the curfew hours again?
He can leave at 6 a.m. and he has to be in by 9 p.m. So from 9 p.m.
to 6 a.m.
he has to be home.
Okay.
All right. Good luck to you, Mr. Perez.
Thank you, sir.
Last case, Judge 15, position 15, Mr. Roberts.
Good afternoon, Mr. Roberts. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. How you doing too?
Thank you. Thank you. I'm doing fine, Mr. Roberts. You've been charged in case 22 CR 0000538H with battery. Is there a history, Mr. Howard?
20 total. Last arrest was April 2021. Suspended license. December 2020, suspended license. 2019, probation violation. 2017, probation violation. 2015, DUI, endangering a child by driving under the influence. 2 counts. and suspended license. Everything was a conviction except for the suspended license. 2013 probation violation. 2011 contempt of court. It was for driving. Let me see. He had a 07 arrest for simple assault that was dismissed. I didn't see any recent violence. 2002 simple battery conviction, but he wasn't recommended because of all the probation violations.
Ms. Mitchell?
Yes, Your Honor. In this case, the defendant battered Miss Bianca Doucette spelled D-U-C-E-T-T-E, by punching her in the left eye with a closed fist and causing a serious black eye bruise. Doucette was arguing with the defendant, who is her ex-boyfriend, when he turned violent and attacked her. He jumped on Miss Doucette and then punched her in her eye. Your Honor, the state's recommendation in this case is going to be a $3,000 surety bond, no further contact with Miss Doucette, a stay away from address 5448 Sierra Trail, Atlanta, Georgia, a one-day anger awareness course, and no alcohol, drugs, and weapons. The state's concerns here is defendant's risk of reoffending. He does have a violent history, 2 simple battery convictions, and 1 simple battery arrest. And he has also had 7 probation violations, 3 of which have been revoked. So that's going to be the basis of our recommendation, Your Honor.
Ms. Kim?
Yes, Your Honor. Mr. Roberts has been a very hardworking father of son who is only 14 years old. And also he's been very responsible. After graduating from high school in 1995, he worked as a barber at barbershop for 4 years. And after that, he has started his own company called, I don't know the name of it actually, but he has been working as a construction worker to do the concrete wall. He operates dump trucks and different machines for the construction to build houses and even commercial football field for the last 23 years. He's been working hard to take care of his family. And actually this coming, it could be today or tomorrow, his niece, who recently lost his mother. She's only 21 years old, and then she's about to give a baby, and there's no other people than Mr. Robert who can support her financially. So we would like to request for surety signature bond, and yet with all those prior issues, I believe that nothing is really related to the simple battery. And actually the simple assault was dismissed, and those batteries were so long time ago. So recently he has not had any kind of battery related conviction at all. And we would like to request for a signature bond, if it is not approvable, we would like to request for $200 surety bond, Your Honor. Thank you.
All right, $2,000 signature bond through pre-trial per the judge, one-day anger awareness class, no further contact with Ms. Doucette, stay away from the Sierra Trail address, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Roberts.
Thank you. I appreciate you all.
Thank you. Thank you.
All right, that does it with courtroom 2 today.
Yes, we're completed here, Judge.
Okay, thank you so much. We appreciate it.
All right, thank you.
And do we have the South Annex on the line?
I can give them a call real quick.
Okay, thank you. Let them know we're ready for them.
What happened with number 16?
I guess we're at the South Annex.
That's a male.
Oh, it is?
Yes.
Courtroom 2.
Come on, Miss Mathis.
Do we still have courtroom 2 on the line? What happened to position 16?
16, let me take a look.
White,
Let me find out with my other coworker and see what's going on. I'll get back.
all right, thank you.
You're welcome.
Okay, South Annex. Officer Milton,
Yes, sir.
put the camera back on you, please. You need to know how to better plead your case, okay? Had
Yes, sir.
you told me you only have 2 cases, I would have taken you first.